Welcome, Rohan. And by virtue of my association with you, it's quite difficult to actually introduce you. So I request that if you can say a few words about your organization and yourself, please.
Thanks, Colonel Koshy, for having me. I'm Rohan Bagai. I'm a senior partner with a law firm called AZB. AZB is one of the largest law firms in the country. I have been associated with the firm now close to 15 years. Over the years, I have dabbled with multiple practice areas at the firm. Over the last decade or so, I have been focused on technology sector, advising a lot of digital companies on their legal and regulatory matters, with a special focus on financial services. Data protection and DPDP is a natural extension to the practice of a technology lawyer, and that is what I think excites me about this space. We are right now at a very interesting phase as a part of the legal profession, where all businesses are moving from offline to online. The discussion regarding data protection, particularly DPDP Act, couldn't be at a more opportune moment.
Right. I know you are working on a very larger frontage with respect to fintechs, and one of the challenges is the provision of section 5(2) of the DPDP law, which primarily talks of retrospect management when it comes to notice and consent. I know it may be difficult for the financial sectors to actually, not only the financial sector, all the sectors to actually adopt to this aspect of ensuring consent to those legacy customers or legacy clients that they have. What is your opinion on this aspect, and how should corporate address this?
Yeah, thanks, Colonel Koshy, for the question. I think the issue of section 5(2) of DPDP Act is a tricky one. Tricky because the law is now also looking retrospective applicability, where data which has been collected prior to the commencement of the law, prior to the law becoming active, is also going to now be governed by the DPDP Act. So the interesting aspect is that the law does provide flexibility to legacy data. So if data has been collected by organizations, whether fintech or otherwise, prior to the law coming into place, there is a flexibility of relying on an existing consent. You may rely on an original consent being obtained and say that I already have something which is in place for processing of personal data. I don't need to go back to the data principal and obtain a fresh consent. So a re-consent requirement will not be applicable as long as the existing consent exists. Having said that, the question of whether the existing consent is adequate, is it good enough, is I think a big question, because historically whenever we've looked at consent mechanisms, these attributes of consent which are flowing from the DPDP Act were never present in the earlier law.
Absolutely.
Which meant that the consent which has been obtained by organizations in the past may not have the same quality, may not have the same attributes of free, informed, unambiguous and consent backed with an affirmative action. So it becomes tricky for organizations to demonstrate in terms of whether they have an existing consent in the first place or not. So if you're sitting on an existing consent, then the good news is you can only provide a notice, a notification to the data principals, and you should be comfortable with that approach. But yes, there will be a lot of operational burden. Organizations will be expected to go back to each data subject, provide them a notice of what is the kind of data processing they have been doing so far, what is the data which is already present with them, what is the purpose for which they have been using it, and if that data is not being used for whatever purpose, then unfortunately you will have to delete it. So any retention of data beyond the purpose for processing is going to be problematic. So yes, organizations will have to go back to the data principles, but the reality is that they will have to be sufficient level of preparedness, and that can only come once you have awareness of what is your data processing practices. You will need to have an inventory of data which is already lying with you. Today, the ground reality is, whether you talk about the financial services sector or otherwise, most organizations may not even have the awareness of what is the data inventory which is lying with them. It's like a situation where you have a warehouse where you have all the goods, but you have no knowledge of the actual assets which are lying within that warehouse. So I think the first step for every organization will be to assess what is the personal data which is already housed within those organizations, and to what use it is being put to. If that data is not being used, then there is no purpose for which you can justify the retention of the data. And in that sense, organizations will have to take a call in terms of whether they can retain that data going forward or not.
Or ask for a consent fresh.
That is right. Asking for a consent would mean going a full circle and asking for a fresh permission of the customer.
I found it that you are more grounded into the industry. So I'm very much tempted to ask you a tweaked question on the same ground. I know you would be dealing with this also in your daily practice. With regard to employee-employer, when a person was onboarded, there was probably there was no consent at all, but there was a contract in place, and now in this new scenario under the same provisions of section 5.2, how would the employee-employer management have to be redesigned to accommodate this compliance?
So the good news is, if it comes to processing for the purpose of employment, you do not require a consent of the employee concerned. The law does provide you with a certain legitimate use, where even though in the past, as an employer, you may have been processing data of your employees based on consents which may have been collected as a part of the employment agreements or whatever onboarding documentation the employee may have signed up for. But where the employer is today able to demonstrate that the purpose for processing of the employee data is directly connected to the employment of the individual, you can rely on a certain flexibility which the law provides, where a legitimate use allows you to process personal data of employees without obtaining their consent. But it's a tricky one, because one will also need to make an assessment in terms of whether the actual purpose for processing the data is connected to employment or not. Because it is very common that employers are using personal data of employees, which may be for certain use cases which may go beyond the strict employer-employee relationship. So in that sense, it becomes very critical for every organization. And this is a question which is often asked upon us in terms of whether DPDP Act applies to my organization. Whether you are B2B, B2C, every organization will have employees. Correct. So to that extent, every organization has a requirement to comply with DPDP Act. And that is where I think the legitimate use becomes very, very critical from an employer-employee relationship point of view.
Okay. Another very interesting question from a new perspective that we see. AI has actually captured many of the industries today. And the use of AI is, especially the Gen Z today, they rely so much on their AI. There is a lot of emphasis when it comes to privacy with regard to social media and e-commerce by the designers of the Act. If you see, there is a mention specifically of these, and there is a retention schedule which is abnormally given to them by 3 years for e-commerce and social media and things like that. Now, you are day in and day out dealing with these e-commerce giants or any of the smaller ones too. Now, with respect to the advent of this agentic commerce that is coming in, what do you think would be the, first of all, is the strategy that they have to adopt to accommodate the DPDP compliance? Also, with respect to technology, what exactly should they look at?
Yeah, that's a great question, Rohan Koshy. Agentic AI as a concept is not envisioned under the DPDP Act. Yes, you can apply certain principles of the DPDP Act in context of the data privacy practices which may be adopted by businesses which are engaged in these autonomous or agentic AI businesses. But when you look at the DPDP Act and the way it is framed, it heavily relies on consent as the basis for processing of personal data. Unlike the EU GDPR, where there are various other grounds available like legitimate interest, contractual necessity, etc. Indian law unfortunately has a very strong emphasis on consent being the foundational basis for processing of personal data, which means that whenever an organization is rolling out their agentic AI model, technically speaking, every agent who's acting for a data principle will have to be processing data in accordance with the DPDP Act based on consents of the data principle. So if an organization which acts as a fiduciary is performing a certain e-commerce function where some of the decisions are being taken by the agents, it could be argued that the nature of the consent which has been obtained from the data principal, the customer of the e-commerce company, may not be sufficient, because at the end of the day, the requirement under DPDP Act is for consent to be specific, it needs to be informed. So the question is, can the consent under the original notice obtained by the e-commerce company factor in all kinds of decisions that a agentic AI solution can take? An agent, let's take an example. If I have to organize a birthday party for my daughter, that birthday party for my daughter can be organized using agentic AI through various mechanisms.
Correct.
The agent can book a venue, agent can have an invite list based on the contacts in my phone book, agent can also book a cake, they can also book the meal or the kind of food which can be served to guests. The agent can also take a call on what are the kind of dietary preferences which should be offered to guests which are coming to my daughter's birthday. So these are all micro decisions which are being taken by the agent. The question is, at what level is there a human involvement? At what level is a human taking a decision? When I as a data principal is deciding to use an agentic AI model and an AI agent is taking these decisions, these micro decisions on my behalf, have I consented to each of these decisions? And problem compounds when you look at an agentic AI model which now in today's time can also facilitate payments. You would have seen new models which are getting evolved where there are large payment companies which are integrating with these LLM models, the Claudes and the ChatGPTs of the world, to also enable payments for merchant transactions. So if in this example, the agentic AI model enables payments for a birthday cake, for a payment to the tent house or the merchant from whom I am availing services to organize my birthday party, my daughter's birthday party, the question is going to be, how well can you articulate and construct a notice which envisages all these micro actions? Great. Is it pragmatic to really envisage what are the kind of use cases which can be covered within the realm of agentic AI? There can be parameters drawn, but is that meeting the requirement of specificity? Is that meeting the requirement of informed consent? Is Absolutely. An individual taking an informed decision by allowing an agentic AI to take these decisions on their behalf? So it is a lot of complexity. It throws up a lot of challenge in terms of how some of these models can be interpreted in the realm of DPDP. As I said earlier, agentic commerce as a concept doesn't fall within the realm of DPDP, but over a period of time, I would expect the jurisprudence will evolve.
Yeah.
There will have to be mechanisms which will have to be put in where some level of automated processing can happen based on a desirable outcome which is being thought through.
Yeah, Correct.
based on the wishes and the desires of the individual, the data principle. Because at the end of the day, the data has to be processed in line with the wish of the data principle. So the question is, are these micro decisions aligned with the original consent which was obtained? Maybe, maybe not. So today there is a gray area there. But time will tell, and hopefully we will have some evolution in terms of how consent architectures can be molded to also fit in some of these new age models which are based on AI.
Got it. Now I want to take you to a more specific, your strong point area of fintechs. You've been servicing fintechs, you've been consulting them, you're providing solutions for them. Now in terms of the DPDP law, of course it is applicable to them, and probably by what we look at, they will become significant data fiduciaries in the line of it. Now, when you look at fintechs, they also have a burden of compliance with respect to RBI. Now, when we look at the data principles rights, it's basically a transfer of the constitutional rights through the DPDP law. Now, from that standpoint, DPDP has also become a burden on these fintechs by virtue of upholding or holding the constitutional right of a person. What do you think could be the best unification of these fintechs who are now burdened by a constitutional right safeguard and also the RBI regulations? And RBI, of course, is very, very stringent in its way. I feel there is a burden. How can this burden be handled by these fintechs? You can give us a strategy that they can adopt.
No, that's a great question, Colonel Koshy. I think first and foremost, I don't think the regulatory expectation as far as data protection is concerned is going to be completely different or isolated from what is there under DPDP Act. When we come to any space, including the financial services space, regulators like the Reserve Bank of India has over the years laid a lot of emphasis on the data protection and the data security requirements which are applicable to their regulated businesses. And to the extent some of these businesses are not even regulated by the RBI, the obligation is on the banks and the other regulated entities to contractually flow down these obligations on fintechs which may be only operating and facilitating these transactions through their tech businesses. So from a compliance standpoint, I do not see this as a burden. In fact, Colonel Koshy, to my mind, fintechs need to approach it as a business strategy. They need to look at it as a trust building governance layer which they are building. Trust is going to be the new currency as far as data protection is concerned.
Wow.
One
Great.
cannot look at it as a checklist item. One cannot look at it as a tick in the box. Trust is going to be very important. And let me share an anecdote with you, which I think quite resonates with me, which I think is going to be applicable to each business today. As a child, when I used to visit my family doctor with my mother, I always used to be very curious whenever I used to walk out of the clinic, that how does the doctor know everything about me? How does the doctor have all the medical details, all the health condition, all the history about me, my family, whenever I'm walking into the clinic? My mother used to tell me the doctor maintains a record. He maintains a register of every patient who walks into his clinic, and that register is maintained in a certain cabinet in his small clinic. Now fast track 20-30 years ahead, where I sit today. Every organization today acts like that doctor who's collecting a lot of personal data, a lot of sensitive information, and they are maintaining those repositories which my doctor used to maintain in a physical cabinet. Now they are being maintained in a digital form, in a server or in a certain digital ecosystem. What is common between what the doctor was doing and what these organizations are doing? It's trust. When my parents took me to the doctor, there was a level of trust. There was a duty of care which the doctor had in order to collect my data and manage it and use it only for the purpose of providing medical advice. Now when we look at DPDP Act and what is the expectation which is being put by DPDP Act, it is no different. Data fiduciaries is a coined term under DPDP Act with a certain relevance. The term fiduciary, Colonel Koshy, means that you are holding data in trust for the individuals. You are a fiduciary. You have a duty of care. There is an individual who is trusting you with the data. So to my mind, every organization needs to build a governance infrastructure so that every individual whose data is being shared with the organization as a data fiduciary is being held in trust for those individuals. It is not about what controls and what are the restrictions the law imposes. I often say this to all clients. Don't perceive DPDP Act as a framework which is imposing restrictions on use of data. It is not putting prohibitions on use of data. It is not limiting your business. It is allowing for use of data responsibly, in line with the spirit with which it should be used and in trust for the individual. So it's very important whether you're a fintech or any organization for that matter. To my mind, fintechs probably are in a better position today because they have already had RBI putting controls, putting checks on how they will be managing data, how they will be handling data in a certain infrastructure which can be secure. So to a very large extent, in my experience, Colonel Koshy, I see the financial services sector or the regulated sectors to be little ahead of the curve when it comes to compliance because they are already ready or they are at least striving for compliance with the sectoral laws. So DPDP doesn't come as an instant shock. It is only an extension of their existing regulatory requirements where they are now looking at a larger framework as far as data governance is concerned. So data governance under DPDP Act should be perceived as a business strategy. It should be looked as a trust building strategy. It should not be seen as a burden. It should not be seen simply as a compliance tick box. Yeah. Organizations which are able to manage data well are the organizations which will grow. They will be able to retain the customers. They will be able to have the stickiness in the models. And that time will come where customers will be able to distinguish organizations based on their data practices. Okay. That is going to be very critical.
Right. In fact, I like to take, with your permission, Rohan, that very fact that trust is the new currency. If you permit me, I will use this in my talks whenever I go.
Absolutely.
Use it. Okay. One more very interesting aspect which I have seen when my visits to these corporate houses. The board and the CFOs have generally been a very, those stingy entities in a particular organization. And I know you would have also seen them as you interact with all of them. And more the reason because for them it is cost cutting or austerity or bringing in larger revenue by virtue of, cost factors and cost cutting and all that. When I have interacted with many of these corporates, they feel that the DPDP law is another cost-hungry venture that they have to invest into. For the fact that they try and cut corners while implementing DPDP law. What do you have to say to these, forget the grassroots level people or the greenfield level people. I want you to give something or a word of advice to the corporate boards and the CFOs and the other higher echelon C-suite personnel with regard to implementation of this DPDP and the vitality of it.
No, you're absolutely right. So when we talk about the boards and the CXOs, we've actually seen quite a mixed reaction when it comes to data protection and DPDP compliance. Very often we come across senior leadership which perceives data protection compliance as a burden, as a cost center, as something which is unnecessary. And I think very often we are posed this question as lawyers. If we do not comply with DPDP Act, what is going to be the consequences? And that is often, Colonel Koshy, the starting point of any conversation.
Absolutely.
That what is going to be the result or the consequence if we do not comply or we are found guilty of non-compliance. So I think that is the reality of today. But I think from a long-term perspective, as I said earlier, if we perceive data protection as something which is going to build trust within the minds of the customer, the data principal whose data is being processed by organizations, it will eventually have a ripple effect on how organizations, their valuations and their governance standards are being seen by the market. It is very common practice across the world. India will also get there, but it's very common that when you look at merger and acquisition transactions which involve large organizations where a lot of data is housed within the organization, data and customer base is seen as a huge asset. It is seen as a value which is very integral to the transaction when any organization is getting into any kind of a restructuring or any kind of a M&A activity. Indian organizations will also eventually, after DPDP Act, come to a certain stage where their preparedness with data protection laws, their data hygiene, are they managing their data well? Are they able to structure their data in a manner which can be demonstrated to the acquirer or to the organizations, the investors who are going to undertake due diligence exercises of organizations? Are they able to demonstrate and establish to them that their internal governance mechanisms are at par with the world? We will eventually arrive at a certain stage where data protection governance will become an essential aspect of any due diligence, and we are already seeing that happening. There are M&A teams within our law firms who are often now asked about the data protection compliance and the data governance hygiene of organizations, of targets in case of transactions. So when some of these questions start getting asked at the leadership level, the CXOs and the board members are going to wake up to the reality that it is very important for their organizations to not simply look at this as a tick in the box or a checklist item. It's something which is actually going to help them drive valuation. It is going to help them become an attractive proposition, because as I said earlier, data is an asset, but only if it is structured in a manner which can be monetized by an organization. If you have tons of data, but you don't know how to use that data to your advantage, that organization cannot benefit from that data. So it becomes very, very important for leaders and organizations, board members and organizations to wake up to this reality. And I am of the firm belief that this is going to be the future, even in India. Yes, you're right. Today we find it hard
to convince
organizations because this is seen as another compliance item. But as I said earlier, one should not perceive it only as a compliance item. This is a trust building factor. And I think it goes back to the fact that organizations need to look at use of data as a competitive advantage. It will drive revenues, it will drive customer acquisition, it will drive revenues even in scenarios where you do not have business. It will ultimately be able to, you will be able to utilize data for new business channels which you've not been able to do today. But you need to have the right fundamentals. You need to have the right consent architecture. It's simply not about having those privacy policies on the websites. Very often when we walk into a client's office, the first thing we hear from the leadership, oh, but we have a privacy policy on our website. You just have a look at the privacy policy from a data protection law point of view, and I think we should be good. So the realization of data protection in practice versus in theory will come over a period of time. And that is what I think the real data governance is going to be.
What I take, Rohan, by virtue of what you spoke with so much of wisdom, I feel in the days to come, the deadwoods will be thrown into the fire. The ones which really stand the test of DPDP will survive in the market, and the ones that probably are. Do you agree with me or?
Oh, absolutely. I couldn't agree more. it is going to take some time. It is not going to happen overnight, Colonel Koshy. It is going to be a cultural change. Today, as individuals, we think very little about data being shared at a drop of a hat. As and when we become more aware, as individuals, when we are parting with our personal data, organizations will also now become more, I think, prepared, more responsible in terms of how they use the data.
Yeah.
And that awareness, that education is very, very important. It is very often left to the government to come up with a law. Government's job is to formulate a law, but it is going to be the role of organizations, role of industry bodies to bring this awareness, ensure that there is a level playing field, ensure that there is going to be awareness so that the customers who are sharing data with organizations have the level of trust in terms of how their data is going to be used. And that, I think, eventually is going to be the decider.
Okay. By virtue of knowing you, Rohan, for so many years now, I am also a consumer in those terms. So as a rightful consumer and a rightful data principal, I would like to ask you one personal question. In one way, by virtue of my complaint or as a customer, I exercising my right as a data principal, you're going to levy a fine of 250 crores at the maximum, assuming that it's the maximum. At the same time, when DPDP enactment took place, you abrogated section 43A of the IT Act, where my personal damage, which I used to get some money, was actually made. So tell me, what is that motivation I have to raise a complaint against the fiduciary and ensure that the corrective measures on DPDP is taken for the government's sake?
No, so you're quite right. The law does not provide any compensation to you as a data principal.
Yeah.
There was contemplation of a right to compensation in the earlier drafts of the law.
I believe the GDPR has such provisions,
Yes,
section 82
yes.
and 83.
But I think, to my mind, the government took this call of taking away this compensatory right because of the sheer risk of misuse, where for the purpose of simply getting some money, blackmailing the data fiduciaries and the organizations which are processing personal data of individuals, there could be potential misuse of the provision which allows individuals to earn compensation. So you're right, you're quite, I think, spot on that the law doesn't give you anything in the individual capacity. But I think where this will come in very handy is to allow for an ecosystem to be built where individuals are simply not looking at monetary gains. They're not looking at a financial aspect of data protection, but something which is much more broader than that. The reason also, I think, one steered away from a compensatory scenario is because it very often will lead to a scenario where competitors will look at this as a ploy to bring grievances against their competition with an attempt to allow for these compensatory fines or whatever amounts to be collected by individuals. I think it is what it is. Unfortunately, we can't do much about the law. So you're right, you may not get anything in terms of any monetary fines or penalties. But as far as I think the law is concerned, it does provide for a mechanism where fiduciaries which are found to be found to be in violation of the law will be penalized depending on the nature of the contravention.
Thank you. Thank you very much for answering my personal question. Rohan, frankly speaking, I can continue speaking to you and I can spend umpty number of time with you because you come with so much of wisdom and knowledge that I'm tempted to ask. But I'm restricted to my last question with you, which is a very tricky question, but I think it will make value for many, those who are listening to our podcast. At the end of the day, the fiduciary is becoming answerable for every good or bad doings, even by those of the processors. So I want you to give one good practice that the processors may do or the processor should bring in as a habit to ensure the life of the fiduciary is made more comfortable. And I believe you would face this. Yet there is nothing for the processor, but as a fiduciary, the noose is under the chopping board.
No, so you're absolutely
my
right.
neck is under the chopping board.
So Indian law does impose all the responsibility and the obligations on the data fiduciary.
So I want to give you an advice to the processor to enable the fiduciary to manage their ecosystem.
Yeah, so I think processors have a role to play. They will be processing data on behalf of fiduciaries. But I think at the same time, a lot of risk emanates from third parties as far as fiduciaries are concerned. So it becomes important for fiduciaries to have the right controls and have the right contracts in place, the DPA in place. See, contract is only half the story.
Yeah.
Contract is only something which is there in documentary form. Eventually, you will need to walk the talk.
Yes.
You will need to eventually have those mechanisms to track the processing of personal data by processors. So, I think one advice from a fiduciary's point of view, you should not leave it to a contract. DPA is essential. You must have the right verbiage under the contract. You must have the right safeguards under the contract. But you should also be able to verify. You should also be able to track. You should be able to monitor the processor's compliance for the reason you cited rightly. It is the processor's wrongdoing which could lead to a fiduciary coming under scrutiny.
Correct.
The fiduciary getting liability under the law. So it becomes important for fiduciary to secure not only its own data processing practices, but also practices of its processors. As far as processors are concerned, I think one aspect which is very critical is you should not see yourself as someone who's not covered within the ambit of the law. Processors are accountable to the fiduciaries. Processors will eventually lose business if they are not able to demonstrate the right data governance practices. And why is that important? Is because if the fiduciary has to trust the processor with the processing of personal data of its own customers, the vendors, etc., they will have a very high bar of checks when it comes to hiring or onboarding a processor. So from a processor's point of view, it becomes, Colonel Koshy, very important to set the right discipline, to set the right framework in place so that you are someone who is desirable in the industry. It is not good enough to say I am good at doing my job. It is not good enough to say that my data processing activities are in sync with my contractual obligations. Processors very often are outsourced service providers where they are performing functions, processing data on behalf of certain service recipients who are fiduciaries. It is not good enough to say, oh, I am aligned with the legal expectations which are there under the contract. You now need to go a step ahead. You cannot sit based on a contractual covenant and say that I am in compliance with the law. And that is the reason, if you look at the way the DPDP Act is framed, which is on the lines of how other geographies have also looked at it. They put a very high bar of compliance on fiduciaries to say that you need to ensure that the reasonable security safeguards are being put in place not only at your end but also at the end of the processors. You need to have technical and organizational measures in place to ensure that you have the sufficient infrastructure, you have the sophistication and the finesse to decide how you are processing the data. So for a processor, it is very important that if they want to stay relevant, if they want to be competitive, if they want to get business, they have to have the right data governance practices. You may be good at what you do as far as your services are concerned, but if you don't have the right governance, you will fail the test of onboarding. You will fail the vendor onboarding requirements when it comes to a fiduciary onboarding you. So it is not about law. It is not about DPDP not being applicable directly to processors. It is about the fact that you need to maintain the same level of data hygiene in order to ensure that you remain relevant and within the parameters of the law.
I'm just echoing what Rohan said, and this is a golden word, I believe. If processors don't manage the privacy hygiene and the privacy behavior, good behavior, then you would be losing your business, and they would find, the fiduciary may find another processor who would comply to those aspects. Thank you very much, Rohan. We are pleased to host you, and we really found a lot of information. I hope this is viewed by all your fintech clients to drive value out of whatever you have spoken, and you've spoken so much that I think one could actually compile a book from what you have spoken. But thank you very much for coming.
I'm very grateful.
Yeah.
Very kind of you, and thank you for having me once again.
Yeah.
It's been an absolute pleasure. Thank you, Colonel Koshy.
Thank you, sir.